Oh, yay, oh, yay, oh, yay. This Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you, Madam Clerk. Welcome, everyone. This is the November 9th, 2021 session of the Court of Criminal Appeals here in Nashville. We're conducting oral arguments via Zoom today. And in that regard, I want to thank Ms. Lindsay and Mr. Hivner, the clerk's office, and in particular the AOC and their technical folks like Nick Morgan for putting this the technology together for us to conduct arguments in this fashion. We're all very anxious to get back into the courtroom, and hopefully that'll come very soon. But during the pandemic, this technology has enabled us to go ahead with oral arguments, and we're grateful to be able to do that. We will conduct this proceeding just as close as possible to how we would if we were in actual court. Each side gets 20 minutes to argue. I need to introduce my colleagues up here today. Judge Robert Holloway from Columbia and Judge Ross Dyer from Memphis. And I'm fortunate to have these colleagues here today on the panel. My name's Robert Wiedemeyer. I live here in Nashville. As I said a minute ago, each side gets 20 minutes. Appellant, if you wish to reserve some rebuttal time, let me know on the front end and I'll help you keep up. I understand you'd like to have 3 minutes. Is that right, Mr. McNeil? All right.
Yes, sir.
Very good. I think that's all the preliminaries we have this morning. So, Madam Clerk, if you'll call the first case, please.
Rashad Dwayne Say Jr. versus State of Tennessee.
Thank you. Mr. McNeil, you may proceed.
Thank you, Your Honor. Good morning. My name is Shane McNeil, and I represent Mr. Rashad C. in this post-conviction matter that's before the court today. It's started a long time ago. I believe it was 2011 when Mr. C. was convicted, and a long process of post-conviction to get here, and we finally had a hearing in 2019 and got a judge's decision which led to this appeal. The chief issue on the appeal is whether a judge's ex parte communication with the jury, and in particular in the manner that this happened, violated Mr. C's right to be present at all stages of his trial. We raised a couple of other issues and along with this, but the communication between the judge and the jury outside the presence of the defendant is really the chief issue that we're looking at. The Rule 43 in the Rules of Criminal Procedure lays out a rule for the presence of the defendant, and it simply says, unless excused by the court on defendant's motion or as otherwise provided by this rule, the defendant shall be present at the arraignment every stage of the trial, including the impaneling of the jury and the return of the verdict and the imposition of sentence. What happened in Mr. C's trial is found. It was the exhibit that was produced at the post-conviction hearing, page 258 of the transcript. And if you will, I'll summarize this quickly. The jury was out for deliberation, and the jury came back with a question that the question, the judge read it on the record inside the courtroom and says, does the fine set the offense specifically for the range guidelines apply to each individual count or to both counts together? And the judge quickly, explained what the answer would be and looked over at Mr. C's attorney that represented him at trial, Mr. Parrish. And Mr. Parrish simply says, that's fine. General Lawson, the prosecutor, said, that's fine, Judge. And the court says this. It says, all right, I'm going to go back there and tell them the fine is separate for each count. And like the verdicts, They can find one count, both counts, or no counts. But they can only set a fine if there's a finding of guilty in that particular count. And then he goes on and he says he's going to put on a robe and go do just that. And then that's where the record stops, as far as knowing what went on there. So in Mr. C's position, he's sitting in the courtroom, and you can imagine he's sitting there, and we, as a lawyer, we can appreciate what's going on, and that is that, you know, we've had a long day at trial, jury's out for deliberation, and we want a decision, we want to wrap this up, but Mr. C is sitting there, and he's got a lot of things going on in his mind, and his testimony is that I believe the word was that he somewhat showed some objection to what was going on to Mr. Parrish, but everything appeared to happen so fast. And it goes on, the judge goes back in the jury room and comes back, and the jury comes back with a verdict of guilty on 2 counts of the sale of cocaine.
Let me ask you a couple questions. Is there anything improper about the actual instruction that the trial court told the parties he was going to give?
No, from what we know from the record. The judge said what the answer was going to be, and that answer was appropriate.
Okay. And no one objected when he said, I'm going to go back there and tell them what I just told y'all.
It doesn't appear so. The attorneys each said that's fine. That's on the record. They each said that's fine. Mr. C testified at a post-conviction hearing that he expressed some concern over what was going on, and his word was somewhat. So it's not exactly clear what's going on.
Well, and then that leads me to my last question on this then. Well, I guess one, is the trial judge the same as the post-conviction court judge?
No, I believe it was Judge Durham that did the trial, and Judge King did the post-conviction.
Did the post-conviction court judge make any credibility findings whatsoever on this issue?
I might have to read this a little bit more just to be able to say with certainty there. I don't. If you will, just give me 1 second. I believe it's right here. Your Honor, I'm not going to say with 100% certainty. I don't believe so. I don't think there's a lot of dispute in what happened. I think actually, I don't think Judge King addressed Mr. C's testimony in regard to this issue.
Okay.
Mr. McNeil, let me ask you a couple of questions too. I think pretty clear that the trial judge is the last person that should have an ex parte communication with the jury. That's typically an appealable error. And they dismissed or waived the appeal and dismissed it. So we're left totally with an issue of whether it's ineffective assistance of counsel not to object to the trial court speaking with the jury. Is that correct?
Yes, Your Honor.
And there was no proof presented at the post-conviction hearing that any of the jurors were affected or the verdict was affected by what the judge told them in chambers. Is that correct?
There was not.
And if there was no effect on the verdict and that you didn't appeal the mere misconduct of going back to the jury room, how are you going to show that it's ineffective assistance of counsel to object to the trial court going back?
Your Honor, it is obviously a very good question. It's a tough one. It's a tough one to cross that hurdle. What the reliance has to be in this case is that it's Mr. C's constitutional right to be present at every stage of that proceeding, and it's hard to see based on the one-page transcript on page 258 exactly timing. It's like, for example, when the judge comes back and he says, would you all prefer that I bring the entire jury back out here and tell them that, or is it okay with you if I go back there in the room and tell them, what do you say, Mr. Parrish? And there's a couple ways that I can see this happening just based on this record. One is that, what do you say, Mr. Parrish? No, that's fine. General Lawson, that's fine. And it happened real quick. And what we see in the case law where we talk about ineffective assistance of counsel is that lawyers are given a lot of latitude in making strategic decisions. But those strategic decisions have to be calculated. They have to be done with much forethought and research and just contemplation of what the outcomes could possibly be. And it's a tough position for an attorney. I've been there. I think we've all been there. And in this case, you can read the transcript in two different ways. One is, what do you say, Mr. Parrish? Oh, that's fine. General Lawson, that's fine. And it's real quick, and there's not a lot of forethought into what potentially could be wrong with that. But yet, according to Mr. C's testimony, he somewhat objected. Now, was that after that's fine or before that's fine by Mr. Parrish? We don't know. The record is silent to that, and there's not a lot of proof. We also have to remember that, and I'm going off the top of my head here, so I apologize. But the trial was in 2011, and then the post-conviction hearing is now 2019. There's a lot of, recall all the specifics, which kind of goes into some of the other issues that were raised on appeal, and I can address those too. But in one way, it could be a real fast process. In another way, it can be, well, maybe Mr. Parrish did have a lot of forethought before he said, that's fine, Judge. And maybe that could be a strategic decision. But then I have to steer the court to the Momin case. There's a reason why we put the Momin rights up before a defendant in deciding whether or not to testify at his own trial, because the case law, I have it here somewhere, the case law supports that yes, it was State versus Blackman, a Tennessee Supreme Court case, says, due to our longstanding presumption against waiver of fundamental constitutional rights, these rights must be personally waived by the defendant. So that Blackman case kind of relates back to the Momin case, where it has to be personally waived, and that's why we go through a whole ceremony on these.
Well, let me go one step further, because it's a post-conviction. That's one of the things that bothers me. This wasn't raised on direct appeal. And so let's assume that trial counsel had a strategic decision to not object to the trial court telling the jury about the facts. And for whatever reason, maybe he didn't want to make the judgment. Whatever the strategic reason was, probably that he didn't think the judge would tell the jury anything that would affect the verdict. Okay. So he goes back. We don't have a record of what the judge said to the jury. And at the post-conviction hearing, there's no proof as to what the judge said to the jury. And I understand it was 2011. It's probably impossible to get. But how can you show that the strategic decision by the trial attorney led to some right other than just a technical right being violated? It's a constitutional right, but without being able to show that the jury was affected somehow by what the judge said, how can you show an effective assistance of counsel?
I'm having to go back 2 years here to the post conviction here, and I remember we looked at a couple of things. One of the issues that we raised up on the post conviction was the makeup of the jury pool, and I don't remember exactly what all was done in finding that out or what the problems were. I think there was a problem in figuring out what the original jury pool was or something, and then it was a whole collection of going 8 years back of exactly what happened. Even the attorneys that were involved in this case didn't have a clear memory of everything that was done. There were some things that were pretty evident in their testimony, particularly Mr. Parrish's testimony, and then one of the issues was the identification expert that were raised up, and some of that seemed to be pretty clear from Mr. Parrish, but even that wasn't 100% there. I apologize. I think that's what it was, is that it is tough because we were going back 8 years and nobody could really recall anything, and there wasn't a lot of records there from what I remember on the jury pool either. But I can't remember exactly what all we did there. So Your Honors, this is the chief issue, and really to narrow it down, and I get that with the ineffective assistance of counsel is whether or not that could be a strategic decision, or is that one that should be better left for the defendant to make and personally waive, as what is given in the State versus Blackman case that I just read that quote from you to you from. And so I do think that is where the chief issue of all this case is. We did, I don't want to be remiss on the other issues that were brought up on appeal, and to address those real quick. There was, I mentioned the identification expert. Mr. Parrish's testimony is pretty clear there. And it's a similar thing where we didn't have an identification expert come in and testify at the post-conviction hearing. And that is one that we had some facts and trying to push things through, and relied on the testimony of Mr. Parrish to go forward. But in full candidness with the court, that is the issue. That is the lesser of the issues that I think we can succeed on. The other big issue that we do have is the direct appeal that you mentioned. So what happened with Mr. C is that there wasn't an appeal, and it was pending, and he did have some other charges against him at the same time. And I guess to summarize it all up, from what we gather from the record is that there was an agreement from the state to drop the other charges if Mr. C dropped his appeal. There's some discrepancy in the testimony here between Mr. C and Mr. Skeen, who was the attorney representing him on the appeal. But the record and the PCR court supports Mr. Skeen's testimony here. Mr. C did, obviously, he's doing a lot off of memory, and he was in custody during all this time. But this record supports that there was about a 4 or 5 day window between the deadline to file the brief for the appeal and when Mr. Skeen appears to be in first, at least real quality communication with Mr. C about the appeal. And through through all that, there was some documentation that Mr. C ultimately signed, waiving his direct appeal. And the contention there, Mr. C's testimony is that he didn't have a full awareness of exactly what that meant.
Let me ask you this. If we grant you PC relief on this issue, doesn't that undo his entire guilty plea and make him subject to those 60 plus years that were part of this guilty plea?
This verdict, this was a jury verdict. This verdict, I believe he was sentenced to the maximum on it of 36 years, I think 18 years per count. And then these other charges were in addition to all that, and that's what the DA agreed not to pursue.
That's what I'm saying. If his argument is I didn't knowingly waive my right to appeal on this case, and part of the deal for waiving his right to appeal was they created another deal with this other charges that he was facing up to 60 years on, then we're basically undoing the entire deal, and he's facing 60 years on those other charges again. Does he understand that?
He does understand that.
Okay.
And I guess that would be a decision for the prosecutor to proceed with those other
we don't
charges.
make that decision, but he would be, if you undo the deal, then everything's back on the table, is my point.
And he's certainly aware of the potential of a new trial that we're asking for on this case. He's certainly aware of that, and to take it from there. Mr. C is definitely engaged in his cases. He's that's just what he is. Which I can tell you that he is very involved in his cases, and he spent he spent several years in prison doing a lot of research on this case. He followed the original PCR, and he's well aware of that.
Mr. McNeil, you got a couple minutes left for rebuttal. I just want to let you know, we've asked a lot of questions, but you're getting into your rebuttal time. Also, one thing I neglected to say at the outset, we have read your briefs. You probably covered some things in your brief that you may not have time for at this point. But if you want to have a couple minutes rebuttal, we better turn it over to the state at this point.
And I appreciate that, Your Honor. I think that does summarize what I need. So yes, please.
All right. Thank you, Mr. McNeil. General Ward, you ready?
Yes, Your Honor.
Go right ahead.
Good morning, Your Honors. May it please the court. My name is Garrett Ward, and I'm here today on behalf of the state of Tennessee in the matter of Rashad C. Jr. versus state. Your Honors, like Petitioner's counsel did, I'll largely focus on what he's deemed the chief issue in this case, which revolves around a jury question. Sort of in summary, Your Honors, what occurred here is the trial court, shortly after the jury retired to deliberate, received a question from the jury about sort of the procedure for setting fines in the case. The trial court received this question, asked counsel for both the state and for the petitioner, told both counsels that, I can go back into the jury room and answer this. Would you be fine if I, rather than call the jury back into court to answer this question about the procedure for setting fines, would you be fine if I went and answered the question in the jury room and then proceeded to say on the record for both attorneys what its answer would be? And at this point, both attorneys for the state and attorney for the petitioner assented to this procedure. So that's
general. We haven't read the record, but as Judge Wiedemeyer says, we've read the briefs.
yes, Your Honor.
But I get so based on the briefs, the instruction's correct. No one objected. But what we don't know is what happened in that room. And we don't have, as I understand it, the post-conviction judge really making any findings as to, I've known this, even if he had said, I've known this trial judge for years, I find him to be an honorable man, whatever, anything. We don't know what happened in that room. And even though the instructions are correct, what if a juror asked another question and the judge forgot to come tell us that he asked another question? We have no idea what happened in that room.
Your Honor, we do have an indication prior to the judge entering the room of the instruction he was going to relay. What we don't have, as is explicitly noted by the post-conviction court, is anything on the record that would cause the post-conviction court to doubt that the trial judge did exactly what it said it was going to do in relaying its instruction. I believe that this court, when this court examines the record in its order denying post-conviction relief, the post-conviction court does make what I would consider an implicit finding of fact in favor of the trial court relaying to the jury exactly the instruction it informed counsel for petition, counsel for the state that it was going to relay. What the post-conviction court says here, in essence, is that in the absence of sort of proof to the contrary, it's not going to find against what the trial court said. So I contend, Your Honor, that is the post-conviction court essentially making a finding in favor of the trial court communicating to the jury the same instruction it put on the record, which, as opposing counsel has conceded, and which this court has noted, is correct. The instruction that the trial court states on the record about the fine procedure in this case was accurate. The post-conviction court found there was no reason to believe anything else that happened based on the proof contained in the record. And Your Honor, I think it's important to note in this case that we're here on post-conviction, specifically on an ineffective assistance of counsel claim. Opposing counsel, I believe, conceded in his argument that we are here solely on ineffective assistance, that any standalone claims here would have been waived by virtue of the lack of objection at trial and the lack of pursuing this claim in petitioner's direct appeal. So we're here on ineffective assistance, meaning that for petitioner to obtain relief from this court, he has to show both deficiency and prejudice. And given, Your Honors, what the trial court said with respect to the lack of proof to make him doubt what the post-conviction court said with respect to the lack of any proof or evidence that would make him doubt the trial court's statements in open court, I believe the petitioner cannot show prejudice in this case. And I'd suggest to the court that neither can he show deficiency. Petitioner's trial counsel, Mr. Parrish, did testify at the post-conviction hearing about this exchange with the trial court. And I believe what Mr. Parrish said is an important consideration for this court, because it shows that his decision to assent to the trial court's suggestion, his decision to not object, wasn't born of sort of lack of paying attention, that this was something he made a deliberate decision to not object. Mr. Parrish noted that even at the post-conviction hearing, even after reviewing the question itself from the jury, that he didn't have any concern about the trial court answering this question in the jury room. What he focused on was that this question asked by the jury was not really directed at the defendant's ultimate guilt or innocence, but was really a procedural question about look, if we're to set a fine in this case, do we set one larger fine that encompasses both counts for which the defendant is charged? Or would, if we decide to set a fine, would one need to be set for each count? This is a question largely about procedure for setting fines. Doesn't really get to the defendant's guilt or innocence. And that's what Mr. Parrish focuses on in his testimony at the post-conviction hearing, that given the nature of this question, he thought it would be highly unlikely that it would impact the jury's verdict. Given that, and that he knew from the trial court telling him what his answer would be, Mr. Parrish knew what the trial court's answer to the jury's question would be. Mr. Parrish also noted that, or he didn't recall receiving any somewhat objection from the petitioner here. And indeed, the record doesn't reflect any sort of objection from the petitioner. So I think that sort of looking at all of this in total, the nature of the question, Mr. Parrish's knowledge of what the trial court's answer was going to be, and his lack of recall about any objection from his client, I think what we have here is a decision that's deliberate and strategic and is within the bounds of professional norms. So given that petitioner can't establish that Mr. Parrish's lack of objection was deficient, and given that he cannot establish that he received any prejudice from Mr. Parrish's lack of objection, he simply cannot prevail here on post-conviction on an ineffective assistance claim based on Mr. Parrish's failure to object here.
Let me ask one question, and this is probably a question more suitable for the appeal, and I'm trying to separate the two. It's hard to do in my mind.
Yes, Your Honor.
Based on your argument, I assume that the case law says this is not structural constitutional error for someone to talk ex parte to the jury. Is that correct?
Yes, Your Honor. Tennessee case law indicates this sort of error is subject to harmlessness analysis.
Okay, so it's not even a non-structural constitutional error. Or is it?
Your Honor, what Tennessee says in terms of harmlessness here is that reversal for an inappropriate communication requires a showing of specific prejudice.
Okay, and who has the burden, the state or the defendant, to show that? In non-structural, the state does. That's why I'm wondering. Yes,
Your Honor. I believe based on the case law, it would be the petitioner would have burden to show some sort of prejudice here.
Thank you.
And certainly on the ineffective assistance claim, which is the only claim that has been properly preserved and presented to this court, that is entirely the defendant's burden. Turning briefly to the two as opposing counsel has determined the two lesser issues in this case. First, dealing with the lack of calling of an identity expert by petitioner's trial counsel. Your Honors, I believe the testimony from petitioner's trial counsel is quite clear on this issue, that he made a deliberate strategic decision to not call an identity expert. Mr. Parrish was actually at the conclusion of the defendant's proof was recalled by the state and specifically questioned about his decision to not call an identity expert. And what Mr. Parrish explained was that he chose not to do so because he didn't see how such an expert would have been appropriate or necessary in this case, given his attack on the state's identification testimony was less about the intricacies of memory and recall and more about suggesting to the jury that based on where the testifying officer who identified Mr. Parrish was standing when he observed this drug transaction that's the basis for this case. Mr. Parrish's attack on the detective here was not the sort of attack he felt would have been buttressed or helped by retention of an eyewitness identification expert. In fact, he specifically testified at the post-conviction hearing. He was worried that there would be a danger of overcomplicating the case for the jury. So I contend that his testimony here is convincing and unequivocal that this is a deliberate strategic decision on his part to not retain this expert. Your Honors, even should this court find his decision to not retain an expert was deficient, since this is an ineffective assistance claim based on a petitioner's complaint that trial counsel didn't call a certain witness. Tennessee law is clear that to establish prejudice for this style of claim, the petitioner needs to call that witness at post-conviction hearing. This court has noted that in a number of cases, starting with the Black case in 1990. The Tennessee Supreme Court has made this same holding in a number of cases. And petitioner did not follow the warnings and instructions of this court and the Tennessee Supreme Court on this issue. There was no such witness called at the post-conviction hearing, meaning that for this claim, as with his previous claim, he cannot establish prejudice. So given his failure to call this witness and trial counsel's testimony illustrating that his decision not to retain an identity expert was a strategic decision, petitioner's claim fails here. Lastly, Your Honors, the petitioner complains about his appellate counsel, Mr. Skeen, and suggests that Mr. Skeen didn't fully advise him of the consequences of dismissing his direct appeal. Your Honor, this question boils down to is a conflict of testimony between Mr. Skeen and the petitioner. Mr. Skeen testified that he had a number of conversations with the petitioner about the wisdom of dismissing his appeal in exchange for the state dismissing a number of other charges. Mr. Skeen testified that he believed, based on these conversations, the petitioner was fully informed of the consequences of dismissing his direct appeal. The record in this case supports Mr. Skeen's testimony and undercuts the petitioner's. There are affidavits executed in this case, both from Mr. Skeen and from the petitioner, about this very issue. Mr. Skeen's affidavit states in no equivocal terms that he and petitioner discussed the likelihood of success on direct appeal, his right to direct appeal, the limitations on future appellate relief, both in the post-conviction and direct appeal context that the dismissal would cause. While the petitioner's affidavit unequivocally indicates that he does understand that he's getting his only opportunity to do a direct appeal, and that he has been fully informed and fully understands the consequences of doing so. While petitioner gives testimony at the post-conviction hearing that, well, I didn't actually understand this, the testimony of Mr. Skeen was fully accredited by the trial court in this context, or by the post-conviction court in this context. Post-conviction court explicitly finds, based on Mr. Skeen's testimony and these two affidavits, the petitioner is aware of the pros and cons of getting multiple felony charges dismissed in exchange for dismissing a direct appeal, and that he made a knowing decision to do so. And Your Honors, the post-conviction court's factual findings here are binding and are due deference. They foreclose a finding here of either of deficiency and prevent petitioner from obtaining relief on this claim. And unless this court has any further questions, the state would request that the judgment of the post-conviction court be affirmed.
All right. Thank you, General. Mr. McNeil, you've still got a couple of minutes if you want to have any rebuttal argument.
Thank you, Your Honors. I do want to steer the court to the State versus Toon case. It was a criminal appeals case in 1993. They reference a Guy case, which is stated in the brief as well. The quote here is, the inability of the reviewing court to determine from the record whether the communication was actually harmless requires a reversal. So I think that's a big statement out of the Toon case that directly relates to this case, where we don't have the record of what went on in that jury room, whether or not there were follow-up questions and what the judge actually said. Also, go back to the transcript on page 258, where the judge, we don't know if he said this in the jury room, but if he said what he said in the courtroom, he tells the jury they can only set a fine if there's a finding of guilty in that particular account. We don't know how the juries deliberate. I think they're all over the place, depending upon the makeup of the jury. But was setting a fine important enough to the jury to find a guilty plea, and how did that negotiation work? I think there's a lot of questions that could be raised out of that. And once again, where there is not a record to say whether or not that communication was actually harmless, it requires a reversal. Thank you, Your Honor.
All right. Thank you, Mr. McNeil and General Ward. Both briefs were excellent, well written. We appreciate that. And we'll get an opinion out on this case as soon as possible. Madam Clerk?
This Honorable Court of Criminal Appeals is in recess until 10 o'clock.